Questions are not something to be feared. Questions are something to be welcomed. In that regard, not every question is hostile. Something that you'll see a lot is judges using questions just to get a better idea about what your argument is. Not every question is designed to set you up for that attack. Probably half the time I ask questions, it begins something like, so, counsel, if I understand correctly, your argument goes something like this. And probably half the time I ask that, the lawyers go, all right, where's the catch? What am I not seeing here? And I will say, it's really not a trick question. I'm just trying to understand your argument. That happens a lot. Not all questions are hostile. Some questions are designed really at face value just to get you to answer the question that's asked so that the judge can understand the argument. In that regard, you want to make sure that you actually answer the question. And this is something that applies at least as much in moot court competitions as in the real world. I remember the day that I argued my case in front of the United States Supreme Court. I was actually first in the afternoon, but everybody has to show up at 9 in the morning anyway. And so you have to listen to the morning's arguments, which is really wonderful. And the case before mine, the lawyer had an amazing tendency to listen to the question and then just kind of, slide by it. And listen to the question and kind of move by that. And never really answer the question. And did that over and over and over. Didn't really answer. To the point that the Chief Justice, it was Rehnquist back then, stopped the proceedings and said, counsel, I just don't understand it. If you're not going to answer our questions, why are you here? Why did you spend your client's money to fly out to Washington, D.C. just so you could duck my questions? And if you look at the transcript of my argument, what you will see is court question. The transcripts never identify the judge, and so it just says court, and then Landau and court and Landau. It'll say court question, Landau, yes, no, exactly, precisely. You don't need to hit me over the head, right? You want to answer every single question, and yeah.
Well, anytime you're framing an argument, no argument is bulletproof. There's no such thing as perfect armor with an argument. And so let's say your question opens up like a line of questioning, which is, is not going to be one that's favorable to your client. Or how does a lawyer, is it in the lawyer's best interest to just engage in that conversation straight away and bring up all these points? What if all of it comes out by opening up and answering your questions, and you don't want to go there?
Would you rather have the court, the members of the court, talking about those very questions without you being in the room? Or would you rather have some input into that discussion?
I guess I'd rather input into this.
Okay, so it seems to me you don't want to avoid it, you want to shape it. So if the court asks you a question, particularly if it's about something uncomfortable, that's your opportunity to shape the discussion. First of all, you answer the question. Whatever the question is, almost always, there's a yes, no, or a maybe, right? Or it depends. Those are perfectly fair questions. Put the answer up front, offer to explain, acknowledge that it may lead down to some interesting complications, and hit them square up. As a general proposition, you always want to be very candid in answering the court's questions, even when the answers are uncomfortable. As a general rule, it's better for you to be answering those questions than for your opponent to be answering them. Okay? Particularly if it's uncomfortable territory, you want to be in charge of that information, so don't be afraid of it. That's another opportunity for you to say, yes, that's, I remember that we had a termination of parental rights case, and boy, the client, the facts were just really, really terrible. And the parent's lawyer came to the podium and said, You know, it is true that my client is the sort of person only a mother could love. And get it right out there. We don't need to dance around. We've got some difficult facts. Let's put it right on the table, and then you be in control of what we do with those facts. In some ways, put your best foot forward, right? If you've got, in the trial business, they talk about drawing the poison. Don't let the other side do it. Be candid with your answers. Even if it leads to uncomfortable territory, that's an opportunity for you to be in control of what the court does with it. Make sense? Other questions? All right. So, as I said, you want to answer the question. That's 90% of oral argument. I remember we had a case, it was a Lowe versus Philip Morris. It was actually a fascinating case as a tort claimant about whether the court should recognize medical monitoring damages. It doesn't matter what that means. But the two very, very fine lawyers were on that case, and I told all the law clerks on the floor that they really should come watch the argument and see two of the best lawyers at work. And they did, and when they came back, they were really just bowled over, but not by what you think. Their reaction was, it was nothing like what they'd expected. There was no oration. They said it was like there was a cup of coffee on the podium, and they were just having a conversation with the court. They were so well prepared that it was just amazing to them. And when the court had a question, one or the other of the lawyers would say, "That's a very good question. Here's my best response to that. Let me know if it doesn't work for you. And here's the weak spot in that argument, but I think this is the answer to that." It was just a conversation with the court, and that's, if you think about it in that way, it's a give and a take. The court asks a question, you answer it. The court asks a question, you answer it, right? So there always is the process of listening to the court's question, think about your answer, and then answer it. Okay? Questions about that? Make sense? Some of this is too obvious, I understand. All right? The second thing that you want to remember, in addition to remembering who or why you're there, is remember who your audience is. Your audience is a judge, or 3 judges, or 7 judges, or 9 judges, depending on the court, who is looking to you for help. As I said before, these are judges who want to get it right. They want to avoid reversal. They're looking to counsel for help in understanding the facts of the case, in understanding the applicable law, in understanding the law in the appropriate case that you're asking them to adopt. Particularly in common law cases, where the courts are in the position of more or less policymakers, there will be a lot of hypothetical questions. And the courts will say, so counsel, if this is the rule that you're asking us to adopt, what about this? What about that? And the inclination of a lot of lawyers is simply to say, well, but that's not this case, Your Honor. Well, and our answer is usually, I'm aware of that, and could you answer the question? What if it were the case? So you need to be aware that you're not just talking about your case. Particularly in appellate arguments, the court will draft an opinion. The opinion will be published for the benefit of the bench and the bar to serve as guidance in future cases. And so the courts are always going to be thinking about what are the consequences of accepting one party's arguments or another party's arguments. And so there will be a lot of hypothetical questions. You have to be ready for those. You have to have thought a couple of steps in advance. What are the implications of the arguments that you're asking the judges to adopt? The judges are looking to you for help, and you need to respond to that need. The judge will never have enough time. The judge will always be barely prepared, and that's no slam on the courts. And in fact, I'm very proud of the court that I work on, where each and every case, the judges read each and every brief. In some courts, the Ninth Circuit, some other courts will have staff prepare bench memos, and the courts will read the bench memos, and maybe